Hello everyone, welcome back to our channel. This is Mahek Upadhayay, a legal intern at LEXIS and Company. Today's topic of discussion is initiation of investigation. I have already discussed in my previous videos what an FIR is, how to lodge an FIR, what is investigation means, what are the processes involved in the investigation. So now I am discussing what exactly how an investigation is initiated. So the next step, FIR is already lodged, but as we have already discussed in my previous videos that FIR is only for a cognizable offence, while a complaint before the magistrate is a non-cognizable offence. So we'll discuss the investigation from two point of views. First, from the view from the side of a police officer's investigation or investigation done by a police officer, and other one is investigation ordered by the magistrate. Magistrate himself is not engaged in the investigation, but he ordered investigation. So we'll discuss these two different views or aspects of investigation. So let's start with police investigation by the police. As we know, FIR is lodged. Under section 154 of CRPC. So the next step is to investigate the facts. What is in the hands of a police station is when you get to know about the facts of commission of the offence. Obviously, it should be a cognizable offence before, so that you could file an FIR. But if he is satisfied, when he hear about the commission of the offence, or he get to know about it, either he could directly lodge the FIR, and then he can proceed to investigate the facts and circumstances by directly visiting the crime scene. It is under 157 subsection 1 of CRPC. But what if he found something suspicious in the FIR? Means that when he found something that the facts are not sufficient, so as to sufficient to register an FIR. So what he can do prior to registering the FIR, he can visit the crime scene. He can analyze the facts and circumstances, and then he could file the FIR. So it is also some sort of investigation he is doing before filing the FIR. So it is not necessary at all that lodging an FIR is a requisite condition for initiating an investigation. No. If the police officer is satisfied that the facts in the FIR or the facts in the information received are sufficient to make an offence, so he would register the FIR, and then he would proceed with the investigation with the court's order. But he can also do it without court order. It is not mandatory that he should obtain a court order. If he feels that bidding for an order from the magistrate to proceed with the investigation, that might lead to the delay. That might lead to the delay in justice, or that might lead to fabrication of evidences. Then in that case, he can proceed without orders of the magistrate, but and he can prepare a police report of the same. It is under section 156(3), 156(1) means section 156 subsection 1, that a police officer can investigate the facts of a case received by him, either through the NFIR or by other means that someone calls the police station that so and so offence has been committed there, or and you should reach the police officer without waiting for the order, without filing the FIR. Just directly can approach that crime scene, investigate the facts and circumstances so as to meet a case. But an investigation cannot be completed without filing an FIR, because an FIR needs to be filed either before the investigation is started, or after investigation is come, or during the investigation. But before the completion or investigation, an FIR needs to be lodged. Okay, and what happens after completion of investigation? It is in the hand of the police officer, if he is satisfied that a case can be made from the evidence he has collected, from the statements he has recorded, from the facts he had examined. then he can lodge a charge sheet before the magistrate under section 173 so as to begin with the trial. Or if he is satisfied that that the facts and circumstances are not sufficient so as to make the case against the accused, then he can find a closure report before the magistrate, but he needs to mention the reason, he's mentioned the belief or mention the grounds of his belief that why the facts are not sufficient to make a case against it, and the same copy of same report needs to be sent to the informant immediately. So that was the investigation from the police officer. Second thing is investigation ordered by the magistrate. So as we know, magistrate under section 190 of CRPC can he can take cognizance of a case, but there are three ways are written whereby he can get to know about the offense has been committed. First one is by a complaint received by him or complaint filed before him. Second one is when a police filed a police report. And third one is when he acknowledged the facts by himself or by someone, not a police officer, but someone of a general public. We'll discuss all the three aspects. First one is a complaint. As we know, when a complaint before a magistrate can be filed in two cases: when either the police officer refuses to entertain the same, or if the offense committed is a non-cognizable offense. In both the cases, a complaint can be filed before the magistrate. And so when a police officer refused to file the complaint, refused to register an FIR, then the magistrate on receiving such complaint can order the police officer under section 156(3) to register the case and then to investigate the same. After completion, police will submit a police report or charge sheet before him. So in that case, when on receiving the information or complaint, magistrate order the police officer to investigate the case and register the same. Then here the complaint play the role of an FIR. It is more or less similar to an FIR, which is generally filed before the police officer or police in charge of this police station. Second one was the complaint before of the non-cognizable offence. So in non-cognizable offence, a magistrate cannot direct the police officers under 156(3) to lodge the FIR, because an FIR cannot be made of a non-cognizable offence. So what would magistrate do? He would examine the facts, and he would examine the statements, he would examine the witnesses under section 200 so as to take the cognizance of the case. Then if he is satisfied, then yes, all the witnesses and evidences and facts are sufficient to make the case, then he can issue a process under section 204. But if he is not satisfied, if he feels that something is missing, if he is confused that whether these evidences are sufficient to make a case or not, then to remove this confusion, to come on a decision as to whether a case has been made or not, he can direct police officer or anyone of a competent authority to investigate the facts under section 102. Okay. So the next one is when police officer submits a police report. An FIR is lodged before in the police station. Police officer investigated the offence and then submit the charge sheet. If magistrate after examining the charge sheet is found that some more investigation needs to be done, then he can order the police officer to reinvestigate the cases or reinvestigate the loopholes the magistrate found in the charge sheet, and then ordered him to again submit the police report after investigating further. Third one is when he acknowledges himself. So it's a cognizance he can do after in the case where he acknowledged the facts himself, and the case when the complaint is of non-cognizable offence, the process more or less would be same. In both the cases, he would examine the facts by himself under 200, and then if he is satisfied to proceed with the trial, then he would issue a process under 204, or else he would postpone the issues and would direct the police station or someone competent to do so, to investigate the facts so as to decide whether the case can be made or not. So that's all about the initiation of initiation of investigation as mentioned in CRPC. So hope you like this video. Do like, share and subscribe the channel. Thank you.